It is Joni and I today, as always. Today we're going to be talking about defects. We're going to come in at this more like practically speaking, like we're not going to go over the inspection contingency in detail where one might expect we would, go over defects. I mean, of course, that's all it will be mentioned and discussed in terms of best ways and best practices to negotiate defects, like within the inspection contingency, but we're not going over the inspection contingency like line by line as we've traditionally done. There are trainings for that on our YouTube library, as we always refer back to, and we'll in the chat after this point you guys back to the YouTube library. It's always a good refresher. I always say to make sure that that is bookmarked. There are just, a lot of resources, within our YouTube library. So again, all things that we've all trained on. So we would just love to refer you guys back to some key points and trainings. Okay, so defects, we're going to be going over defining defects, identifying defects, disclosure of defects, and negotiating defects within our transactions. So, and it starts, well, we're going to talk about it in terms of from the buyer's perspective and from the seller's perspective. So first, a defect is defined, and it's defined in both our listing contracts and in our offer to purchases. So a defect is defined as a condition that would have significant adverse effects on the value of the property, that would significantly impair the health or safety of future occupants of the property, or 3, if not repaired, removed or replaced, would significantly shorten or adversely affect the expected normal life of the premises. I like to be able to see at least one person. So using this definition, the seller now and buyer now, consumers, clients would use this definition and respond accordingly. So from the seller's perspective, they need to use this definition to go ahead and disclose defects. So disclosing defects as a seller, we're going to use the real estate condition report. This is a state requirement. This is not, this is Wisconsin state requirement. This is not within the scope of, agency law. All sellers need to fill out a real estate condition report unless they are exempt. We're not going to go through those exemptions right now. That is covered in another training. But that is the vehicle that they would use to disclose any defects that they have on the home. They need to have this prepared for the buyer to receive and review either prior to writing an offer or within the following days after an offer is accepted. So the buyer has the right to know any defects on a home. When we are giving the real estate condition report to our sellers at our listing appointments, we cannot advise them on how to fill out the real estate condition report in terms of like what a defect is or not. They will also be referring back to that definition of a defect. But we can let them know that every question needs to be answered. That is very important, and something that actually I don't know that we were making it a point to look for. I know it wasn't something that I was making it a point to look for, but we need to make sure that every single question is answered in some way, whether it's yes or no or non-applicable. If you do see a real estate condition report that a question is not answered, then we need to send it back to them and ask them to address that question. It could be determined that the condition report is not valid, and buyer's rescission rights could come into play if that is the case. So this is a protection for your seller as well, because we don't want to give any out to the buyer if it can be avoided, right? So, and then also we can just stress the importance of disclosure. So when I'm in front of my sellers, I'm saying I cannot advise you on how to fill this out. But I will say just disclose. Jody made a point that the seller has to be convinced that disclosure is the most important protection to prevent future liability here. So it's in their best interest to over disclose. It just protects them from post-close issues. You're not going to hide from anything. So our job is to keep them out of hot water. So that is, again, just how I approach it with sellers. Sometimes sellers, if they have more specific questions beyond that, I have given them examples of other real estate condition reports as a guide. And feel free to use that as well. I mean, I've got examples of real estate condition reports where a seller has, disclosed everything under the sun, and then attached pages detailing what the defect was, how they fixed it, just kind of going overboard. And I thought that's always going to be a great example for me to use to show somebody in the future. So don't be afraid to do that as a tool to help you if they have questions regarding how to fill these things out. I'm going to stop there with any questions that anyone might have.
Yeah, you know what? I have one. So you mentioned that could be a way, if it's not done properly, that could be a way for a buyer to back out potentially.
Yes. So rescission rights could come into play if they have not been given a fully completed real estate condition report.
Right. So I feel like I've seen a lot of really bad condition reports where it's not well filled out from a buyer's agent side. So on a listing, and I kind of know it's not complete. Do you just roll with it? And, is that a way to get out? Or do you have to, because I've always feel like I should tell the other agent, like, hey, this is complete garbage,
Well, I guess it depends on how, if you're seeing we went over this, that if you're technically seeing strike throughs on pages, it does not make a complete condition report. This is a hard one to answer in that it depends on the situation. I guess it's reminding listing agents, this just has me concerned because a buyer does have could have rescission rights here. We have to also be careful on how we're wording these and phrasing these
right
things. So
yeah, sometimes a listing agent or a seller, say if they're exempt or they don't know or whatever, will put a big X across the whole page. That is something I wouldn't accept as a buyer's agent. I would take it back to the listing agent and say, this is considered not complete, and I would like a complete one, especially if the seller is not exempt and should be filling it out.
Mm-hmm.
Yeah, I guess one of the weird issues is like I'll see things where like maybe a defect circled, but there's no explanation, or they just miss circling stuff, things like that. And obviously the market's not as crazy as it was before, but if you're, telling someone like you're trying to put an offer in with the signed condition report and it's maybe not the best, that's what
I think this is a good tool. Using the provisions of the offer to purchase might be able to head this off and state in there, buyer to receive a completed real estate condition report no later than 4 days after, if you're getting pushback from the listing agent, I would say, and kind of, because maybe a listing agent also has a difficult seller where maybe they have recognized that as well. And, they don't maybe sometimes it's hard to communicate, obviously. So like using the offer to purchase as the guide for this listing agent to be able to say, look, now a buyer is asking for this to be complete,
Yeah.
they're putting that right within the offer. So we do need to get this properly completed.
Yeah. So would you
It
mention
saves a
that
lot
every
of time.
time that you see you see a maybe if you make an offer and it's not necessarily the best condition report that you've seen, would you always mention that, or sometimes would you just roll with it?
Well, you can leave it as an out for your buyer if things.
That's what
get
I'm
difficult.
wondering, because I feel like it's a benefit then, because then it's like a secret out, I guess.
Yeah.
It's an advantage to the seller, to the buyer. And the thing is, when it's not complete and all that, you're talking about big waste of time. I mean, to your buyer to receive an incomplete condition report is probably going to lead to a lot of arguments down the road on this transaction. So get it cleaned up one way or the other, or just, and another thing that we learned, the attorney that Keller Williams has hired has said that we cannot explain rescission rights. We can just point that paragraph to the seller to read, but explaining rescission rights actually is legal advice and we shouldn't do it. So it kind of puts us in this, muffled role where read this, but I can't explain it to you really.
And it's always, and to your point too about, whether or not you're in competition. I mean, it might not be something you want to push the point home on, so, it's a case by case basis.
Would I, to do due diligence to my client, at least, would I tell them like, hey, this doesn't look complete, or just like?
Yeah, I mean, we can, here it is for your review. I've noticed that X, Y, and Z questions have not been answered. I have a follow-up question back into the listing agent. If we don't hear from them, we could possibly address those questions in the offer to purchase itself. It might not be something that they have concerns about. It could be things that are non-applicable as well. These are all such gray areas. So I think I would look at the nature of the question. So, but these are these kind of things though, and we'll just cite examples of like real life examples of where, an attorney, if something goes into litigation, maybe they're not even the attorney is going to look at the whole file, and they could look at that and say, this is something that we could use to our advantage, whether or not it's something that was ever like a point of contention to begin with, so they could look at this and say, well, this is the problem over here, and we don't necessarily know how to solve this, but this was the seller failed to disclose and answer this question, so we can use this as an out, so that's why it's really important to make sure that these documents are complete too. It's just, how they're going to get creative with arguing, a potential lawsuit. So does it? Yeah, I'll continue, but hopefully that helps.
Yeah, it's crazy. I wish, you guys were mentoring a lot of the other people, but I just feel like I run into it so much, and I just feel uncomfortable, I guess, because you don't want to lose the deal. You don't want to make it a big deal kind of thing. And
right.
I don't know.
I think it's just knowing the other side, the nature of the property.
But I think you do have a duty to talk to your client about it.
Yeah.
Right.
Because that's what you're doing. You're representing your client. So you tell your client, listen, this is not complete. It's up to you and to decide what we want to do about this.
Got it. Yeah.
I think the next page, back to legal advice. So I'm just gonna go and read this. So practice tip, we're not to give the seller legal advice. So listing agents asking the seller to complete the real estate condition report or the vacant land disclosure report may give the seller a general explanation of chapter 709 seller disclosure law and the real estate condition report form. Agents can tell the sellers copies of the real estate condition report will be given to prospective buyers, for instance, when they tour the house. Agents can explain a buyer making an offer may be able to rescind the offer if the buyer does not receive a real estate condition report. And then if the seller has questions, whether it's a specific item, the seller should be referred to legal counsel. So just we're driving this point home all the time. We're not attorneys. We cannot give legal advice. So that's kind of where, when I was making the point about whether or not something is a defect, showing them examples of prior inspection or real estate condition reports is okay. We're not able to though go one step further and say, yes, no, this is a defect or not. So if they have questions like that, they need to be referred to an attorney. Disclosing defects as a licensed agent. So, part of our process as doing our, when listing a home is we have to do a walkthrough of the home and observe any defects that we might see. So if it is the case where we see something that the seller may not have necessarily disclosed, we need to use our own disclosure form, and that is called the disclosure of material adverse facts. You'll find this in the WRA form library on Zip Forms. And then this is also a point where, you could be going through the home first. And then once you receive that real estate condition report from the seller, compare it against what you have found. So, and then this is where a conversation can happen between you and the seller. Oh, I noticed that this wasn't put on the condition report. What, I need to address this then in the material adverse facts. And then the seller might use that as an opportunity to note that. And it could be nothing of ill intent. It could be something that they just didn't notice themselves, so just making sure that you're aware and making sure that you are doing those home tours and observing defects yourself as the licensed agent.
You know what? I have a quick question on that. So do you do that after the condition report? Or
generally in practice, you're doing it at the time of, and also this can also head off these questions for a seller too, because if you're walking through a home with a seller, like you're going room by room. And so like, especially when you get down to a basement, I mean, you can see a crack and say, oh, what's this crack from, Mr. Seller? Tell me about this. Was this something that was disclosed when you bought it? Or, just, have you done any follow-up on this? So, because that would be viewed as a defect for sure, a crack in the foundation. So then, it's kind of, then you're kind of setting the stage for how the real estate condition report would be filled out for them as well. Or what.
Gotcha. So if you kind of notice something and they don't put it on the condition report, would you ever just tell them, hey, throw it on the condition report before doing your disclosure, or you just add your disclosure?
No, if you can stress the importance of their disclosing it, it's much better than you disclosing it as a material adverse fact.
Right, because it shows like they're hiding something almost.
Yeah, and you just say, if you can't disclose it, I have to, according to my license, I have to disclose it.
Okay.
But remember, it's material adverse fact. So it isn't something, it appears to be something, or appears, like mold is a defect. But if you're not sure it's mold, if you don't have the facts that it's mold, you've got to be careful on disclosing that. The seller can say appearance of mold or things like that. But for the agent, I think they have to keep their disclosure of material adverse facts to facts.
Okay, so if you like saw something like mold, could you say black substance or something like that? Because you don't know, is that how that's handled?
Right, I don't think I'd put that on a material adverse fact form though.
Okay,
I don't know that I would either.
Yeah.
So it's like those blatant things, you know, just
I mean-
any reasonable person that could, you know.
right.
I had one on a listing and it was, this was a very large condominium on Lake Drive down across from Lake Park. So it was huge and old and beautiful. But the seller hadn't lived there for a long time. It had been rented for a long time. And over the garage, there was a flat rubber roof with pillars and posts on around the corners of it. And I pointed out to him that it looked like the rubber roof was peeling back from these posted walls, brick walls of this top of the garage. And he said, that's nothing. And I said, well, it looks like something because it doesn't look like the rubber roof is in good shape. And he actually refused. There's nothing wrong with that. That's fine. It's over the garage. It's no big deal. I mean, it was obvious to me this rubber roof was drying up and pulling back. And so that's the one time that I literally had to pull out that disclosure of material adverse facts, put it down, attach, put it with the wrecker, and people got it when they picked up the wrecker. So I put it on MLS and I put it at the property for potential buyers to see.
Okay.
Okay. So disclosing prior reports or inspections. So the seller has filled out a real estate condition report, but new information has come to him. Depending on where we're at, I mean, if there's not an accepted offer, and we're in the period prior to an accepted offer, then the seller can amend the real estate condition report and provide any inspection report he may have received. So, this could be, after an offer came in and an inspection report was given, or if something was revealed, let's say all this rain, we should.
I had 3 calls today.
Yeah, so, a lot of listings may have experienced a bunch of rain in their basements. So the seller would need to disclose that new information to a prospective buyer. So he would use the amendment to the real estate condition report. What we're saying here, as far as being cautious to amend the real estate condition report, you don't want to amend the real estate condition report during a transaction. We'll refer to a different provision in the offer to purchase if something is revealed. But if an amendment is given during the transaction, then it gives the buyer new rescission rights out of that offer. So we just need to be very cautious of that. So referring to the property damage between acceptance and closing provision. So if something happens to the home between accepted offer and closing, we'll refer to that provision, which basically states if damage is done, it's less than 5% and the cost to repair is less than 5% of the purchase price, then seller is obligated to disclose that repair and go ahead and make the repair and move on to closing. If it's more than 5%, then it puts put in the buyer's court on whether or not they want to move forward. So seller will disclose it's a major defect, and buyer, do you want to continue on knowing this? So that's definitely a case where if something happens and there's it's large enough that you need to come to us with a question on that, just come to Joni or I if that happens. But we definitely get questions on that a lot as far as damage between acceptance and closing. So it's going to happen in your career, of course. And then again, if there's just any questions about something that comes up and that would potentially need to be disclosed, and seller has a question on it, we need to get an opinion from a attorney if there are any questions. So seller can provide previous inspection report to a new buyer, or fill in the new real estate condition, or fill in an amendment to the record with the new information. So let's say we are in a transaction and seller receives an inspection report. Negotiations fail, buyer walks, seller is okay with that. Now seller has this new information with this new inspection report, or this inspection report that they were given as part of that first transaction. They can definitely go ahead and amend the real estate condition report and attach that inspection that they have received to that amendment and disclose their defects that way with this inspection report. So a lot of times buyers agents will say that those inspection reports don't belong to the buyer or to the seller. Per the offer to purchase, the seller has the right to receive all inspection reports done on their home, regardless of who paid for it. So just because a buyer paid for it doesn't mean that it does not belong to the seller. So
and if there are no defects, sometimes the buyer's agent says, well, we didn't send it because there's nothing to argue. They still have to send it.
Absolutely, yeah. And I think that's a good way to disclose newly revealed information, is just to attach the real estate or attach the inspection report to an amendment to the real estate condition report and give that to new buyers.
And I had this question twice. I had basement flooding, 3 calls this morning already on this. But on 2 of those calls, the agent was not aware that there is an actual form, an amendment to the real estate condition report, and it's in the library. So because they've never had to amend it, they didn't know there was an actual amendment form.
And then beyond that, they can take that amendment and address the specific items found in that inspection report. The easiest thing though would be to just attach it to the amendment to the real estate condition report and just have it all out there. So the more information for a buyer, the better. And that's better for the seller as well, because, you know, if a buyer goes into something eyes wide open with all information they can possibly get, and they're still willing to move forward, great. So negotiating defects. Okay, so now we are at the stage of writing an offer. We're gonna now kind of switch gears and come in from the angle of the buyer's agent here. So buyer has received that real estate condition report. We're about to write an offer. Now what? So negotiating defects starts at the time of receiving a real estate condition report and writing an offer. It's not at the time of inspection. So you know, the first option obviously is you receive this real estate condition report, defects are disclosed, and you don't address anything in the offer specifically. But we're going to look at that real estate condition report and we're going to have a discussion with the buyer. Are there any concerns that they have on what has been disclosed in the real estate condition report? I want to take the time to remind everyone that signing a condition report does not mean an acceptance of the defects. Signing the real estate condition report is an acknowledgement. It doesn't preclude a buyer from being able to negotiate on anything that they want or making attempts at negotiating on anything that they want. Point 3 on here, should you address any additional inspections and the inspection contingency right away? So on line 196, it allows for additional inspections of certain areas of the home. So if you see that a buyer or a seller has disclosed older roof, maybe you want to take this time to say that we do want a roof inspection right away on the home, and you'll write that right into the offer right away on line 196. Let's say they disclose a crack in the basement, but they leave little information regarding that crack. And this is where also you're going to have conversations with the listing agent. So, you know, we're getting ready to write an offer. We noticed that crack, the seller or the buyer disclosed, or the seller disclosed that crack. Has the seller done their own follow-up inspections on this crack? Is there anything that we should know about it? You know, if the answer is no, and buyer has a concern, maybe you're going to write in a foundation inspection into your offer to purchase. I've had people request repairs right in the offer to purchase right away. Most recently, I wrote an offer on a home that they're remodeling the basement, and they put the home on the market before the basement remodel was finished. So we wrote in there, make sure that finished carpentry is done, ceiling is added, you know, when we just put it right there into the offer, getting it in writing right away. You know, they assured us it was going to be done. We should put it in writing. Again, back to point 5, conversations with the listing agent. Are there prior reports available? You know, again, this is all just like discussion with the buyer on what they might have concerns with based off of what has been disclosed on that real estate condition report. You know, 9 times out of 10, you might not be doing anything with it. I won't say 9 times out of 10, maybe 6 times out of 10, you're not going to do anything with it. But just know that you have an opportunity to address these types of things in the offer straight away. And then, you know, I'm going to go to 7 first. Should seller be given the right to cure in the offer to purchase? So we'll get to right to cure a little bit later. I'm not going to go into it in depth, but you know, depending on if you're on competition, depending on the nature of the issue that was disclosed. So this crack, you know, that could turn into a $20,000 fix that buyer might say, I don't care if seller is willing to fix it. I want to have the opportunity to kill the deal. I don't want to give them the right to cure. I want to put the ball in my court to kill this deal if it's something large enough that I'm not comfortable moving forward on. I think maybe mold could be a good example of that, or, you know, air quality, or kind of getting into the weeds there, but right to cure is a point of negotiation as well, and what is going to be beneficial for your buyer. And then striking lines 210 to 211. So these are these quote unquote famous lines in the offer to purchase that a lot of people miss. And as a buyer's agent would be advantageous for your buyer to possibly address. So in the offer to purchase on lines 210 to 211, it states, for the purposes of this contingency, defects do not include structural, mechanical, or other conditions, the nature and extent of which buyer had actual knowledge or written notice before signing this offer. So this comes into play at the point of notice of defects, which again, we'll get into in just a moment here. But this is basically stating that a seller or that a buyer does not have the right to serve a notice of defects on things that they've already been given disclosure on. And this becomes a gray area because, and we'll get into it in a minute as well, but you know, there's an example of a disclosure, and then there's what a seller states is wrong with a property, and then the true issue with that issue, the true nature and extent of that issue that was disclosed. So I'll get into an example in a minute, but point being, if we want to make sure that there aren't any gray areas around what is put on a notice of defects, then maybe striking these lines could be considered as part of the offer to purchase. So meaning, if a notice of defects is served and we want to make it black and white, we can say, by striking these lines, it doesn't matter what was disclosed or not. It doesn't matter that I was already told that there was a basement crack. I can use that crack to later get out of, or later put it on a notice of defect. And it becomes very black and white then. And no gray areas around what could potentially be wrong with it. So as a buyer's agent, I would always consider striking those lines to head off any potential issues on down the road.
So as a quick rule of thumb, if there is something that your buyer's concerned about and you would like to add that, like the roof inspection, for example, you would probably almost always strike those then?
Yes.
Okay.
So just more so to make sure that I have that tool in my tool basket to put it on a notice of defects. So, if they, and again, this is where it gets muddy because, a roof leak will be disclosed, but an inspection might reveal later on, and a follow-up inspection later on might reveal that this roof leak is due to, it will be due to compromised shingles, that is the issue now, these compromised shingles, not this roof leak. And we want to put this on a notice of defect as compromised shingles, not necessarily as a roof leak. But if what we're trying to avoid is having that listing agent saying, you knew there was a roof leak, you can't put that on the notice of defects because you knew about it already. So we're just kind of like wiping out that gray area. Hopefully this is coming across effectively to you guys. It's just, again, being able to say, we can put this roof leak on here because we struck those lines. Yes, we already knew about it. But by striking these lines, we are able to put this on a notice of defects. Come to me or Joan if there are questions on that. Again, I think just as a buyer's agent, it's always good to strike them, consider striking them. Okay, any other questions at this point? Is everybody we following okay?
Yep, everything's good.
Awesome. All right. So now we'll kind of move into negotiating defects after an inspection. So once this inspection happens, we're now, doing our due diligence, and what I call now and explaining to the buyers, we're entering the information gathering period surrounding what we have learned on this inspection report. So it's good practice as a buyer's agent to send over the inspection report right away to the listing agent. To me, it is very important to get the inspection report over right away, give everybody ample time to review things. The longer that everyone has to review an inspection report, the better. I think that waiting to send an inspection report over is just setting up for more problems as far as, extending inspection periods, miscommunication, vague communication. So give that seller the opportunity to review their inspection report by sending it over right away. And again, as I had already mentioned, seller has the right to all inspection reports on their home. And it's right in the inspection contingency lines that buyer's agent shall promptly deliver all inspection reports. So I think it's then good practice giving the listing agent a brief summary of what was found at the inspection, but letting them know that you're still discussing with buyer. You don't know exactly what buyer has issue with yet. You don't know exactly what buyer is going to be requesting. Sometimes listing agents want to know like every single little thing so they can prepare their seller. It's, you know, a good listing agent will forward on the report. They'll be able to identify themselves as coming from the perspective of the buyer's agent. You know, these are the things that came up. I'm sure they're going to be, you know, investigating these. We'll wait to hear from them, but here's the report right now. I'll let you know, again, per our conversations, when we went over the offer to purchase, they have the right to have any follow-up inspections. So as a buyer's agent, if you know of any follow-up inspections that the buyer is going to want to have, you can obviously tell that listing agent right away and let them know that you're coordinating it. And again, right now, we're just in this period of getting all the information that we can for the buyer to make them feel comfortable with moving forward. Also, as buyer's agents, making sure that we are negotiating repairs for them, making sure that we are finding out true costs of repairs, which will, again, gathering these tools to put in our arsenal to respond to the seller accordingly with what the buyer might want to see done before they're comfortable moving forward. And also too, whether or not a seller agrees to be doing these inspections or agrees or not to doing these repairs. As a buyer's agent, allowing that buyer to at least have this information so that they can feel comfortable moving forward. Again, just in the vein of eyes wide open. Yes, you're comfortable, Mr. Buyer, moving forward, but you now have the knowledge that it will be a $20,000 masonry repair, which happened to me. And buyer was able to still say he wanted to move forward. And I said, as long as you know that, great. So, and what we're doing here too is preventing any post-close issues that the buyer might have with you. You know, they might say to you, why didn't you help me with this? Or, you know, why didn't we have the opportunity to find out the true extent of this issue? You know, you don't want to have a buyer come after you and be unhappy with you because we didn't help them try and find out the costs of these things. So,
and that's also why when you're putting in the term or the time of your inspection contingency, make sure that you're asking right away for a good amount of time. So some people think in this competitive thing, they either, not talking about waiving the inspection, but they would put down like 5 days or something. There really should be at least 10, at minimum 10 to 15 days for an inspection contingency, so that you both have time to review these issues and negotiate them. Because there's nothing worse than negotiating under time pressure.
Yeah. And another thing to remind everybody too, I mean, this is the hardest part of a transaction by far. So, and this is why we're getting it done with right away. So as long as, like, you know, in our buyer consultations, like putting our buyers at ease, like once we get through this, then it's, you know, pretty much smooth sailing from there. And same with our sellers and letting them know. I think it's okay to stress the importance of the inspection period. Sometimes this period is worse than the offer negotiation itself. So, you know, kind of like right sizing their expectations. Like, this is a hard thing to get through, you know, and you'll know whether or not to have those conversations with them also from walking through the property and doing the showing. I mean, you know, an East Side home, for example, you know, it's going to be a long report. If you're walking into new construction in Waukesha County, you know, newer construction, it's going to change the nature of how you stress the importance of this. But so I just wanted to make sure that was said, just right sizing expectations between sellers and buyers as it relates to the inspection period. So continuing on with this kind of information gathering phase as it relates to identifying defects, how much they cost. So you're going to discuss the report with the buyers, of course, ask their concerns. As a buyer's agent, you know, if there's something that they missed that you think might be worth mentioning. I mean, this is where a buyer's agent needs to help guide their buyers. I think especially with first-time home buyers as well. So just making sure that we're focusing on what has been deemed a defect in the report. Making sure that we're focusing only on defects. That's another thing that we need to kind of right size expectations around. We're not focusing on maintenance and we're not focusing on cosmetic issues. And then kind of determining how we're going to respond to a seller. What has the inspector identified that needs a follow-up inspection. So if you see anything in a report that needs a follow-up inspection, I think as a buyer's agent, I of the opinion that we need to be making sure that we're making an effort to have those follow-up inspections for our buyers. And making those suggestions, if the buyers are okay with it, at least you've had the conversation. But again, this is where our buyer agency hat comes in, and making sure that we're working and negotiating for them to the best of our ability and offering our full scope of services. As a seller's agent, that of course would be completely changed. So, okay, so now we've got all of our information. We've got let's say we've got a bad foundation and we've got a bad roof, and we know that the roof is going to be $5,000 in repairs, and we know that the foundation is going to be $5,000 in repairs. We've got our information, and now we've got everything that we need to respond to a seller and make a request based off of what we have learned on the inspection report. So preparing the amendment. I'm stressing this amendment. This is the tool, the vehicle that we use to make our requests to a seller. So that's that WB-40. We're always, first line in this always is to attempt to negotiate with a seller first. And, whether or not we know how the seller is going to respond, making sure that we at least properly make the request to the seller first. So, and here I wanted to make a point: buyers free to make any requests to a seller. And this is the place to negotiate the conditions of the property that the buyer would want to see repaired or replaced. Using the follow-up inspections as a guide. So let's say we've got a scope of work for this $5,000 foundation issue that includes bracing. So we're going to write on that amendment, seller to complete the following per this follow-up inspection, per this estimate given by XYZ contractor. So we can use that as a way as a guide for us on how to ask for things to be done. Conversations around whether or not the buyer has concerns on whether or not they should be repaired prior to closing, or if the buyer is okay with taking the concession and using that to make the repair after closing. So in point 5 here, I say you can use a combination of repair requests or a price reduction or a seller credit. So again, using that same $5,000 estimate to fix this foundation, instead of saying we want the inspection or we want that repair to be made per the scope of work prior to closing, you can say, oh, it's a $5,500 repair. Seller would like to see, or buyer would like to see, a $5,500 price drop, and then they will take care of it after closing. So it's all conversations happening around the scope of work, the severity of the work, buyers' abilities themselves. I mean, some buyers are handy and they'll just say, you know what, I'm okay with these plumbing repairs. If I can,
Weather, time of year.
Time of year. So negotiating how things are done is also a craft. So, and how, this is another opportunity to call Joan or I and like, okay, we've got this that needs to be done. You know, how can we get through this? You know, sometimes too, contractors are not available, things need to go into escrow. So there's just a lot of, the point here is that there's a lot of different ways that repairs can be made, whether or not it's actually being done prior to closing or, you know, coming to another agreement. So again, you're going to put all of this on the amendment. And I want to go back to point 2 where it says buyer is free to make any request to a seller. Kind of going back to the point about the real estate condition report when it's signed, that it's not an acceptance of those defects, but an acknowledgement. Like buyer can make a request on something that they have learned about at any time. So well, a buyer can make a request on anything at any time during a transaction. So it's just
In an amendment.
in an amendment, yes. It's just whether or not the seller is going to agree to it or not. So I just want to make sure that that point is delivered, that again, buyer.
An amendment is the place where you can, as Steph said, not only talk about what you want repaired or fixed or things like that. They don't have to be a defect. They could be things that they were made aware of in the property condition report. But and they can even say who they want to do it. You know, they can determine and that they want lien waivers and all invoices also sent to the buyer. So all of those things can be an amendment. They can't be in the notice of defect. So the amendment is the only place where you're really talking fully with the seller about what you want to happen to the house before you buy it.
Yeah. And every single detail can be spelled out
Right.
within that amendment. So, gosh, you guys, we're running out of time. So seller's response now, receiving this amendment. So buyer has delivered their amendment. Okay, Mr. Seller, this is what I want to see done before. This is what I would like to see done now that I've learned all about these things in the inspection report. And this is, again, as buyer's agents, we need to remind our buyers and right size our expectations on how a seller can respond to this. So we can make all the requests in the world, Mr. Buyer. The seller can agree to some of them, none of them, or all of the requests that you have made. So during this period, there might be some more negotiating going back and forth via amendments during this time. So, you know, you serve buyer sends over an amendment requesting roof to be fixed, the foundation to be fixed, and a $5,000 credit towards miscellaneous items that have come up on the inspection report. So seller can receive that amendment and say, I'm down with fixing the foundation and the roof, but I'm not going to give a $5,000 credit. You know, and then there might be just going back and forth now between you and the seller's agent here with how to come to terms so that both parties feels comfortable moving forward. It's also very, I started a sentence here and did not finish it. But it's also really important to make sure that the buyer understands that the seller's rejection of an amendment does not mean the deal is dead. So again, it's putting forth these requests. It's still in the buyer's court always on whether or not a notice of defects is going to be served or not. Just because we make a request as a buyer's agent does not mean that the deal is dead if the seller is offended or does not want to do any of them. So just know that as a buyer's agent, like you are able to make these requests all day long. It's just, again, where you're going to go with it if the seller says no. So now we're going to get to the point where a seller does say no. So failed negotiations. So if you're going back and forth between this roof and this foundation and this $5,000 credit, and neither party can come to an agreement now. So where do we go from here now? We've come to this dead zone. We don't know both parties are just not in agreement. So if the amendment negotiating does not come to an agreement, then the buyer can send a notice of defect. It's always in the buyer's court to serve the notice of defects. Now it's the right to cure to determine whether or not who kills the deal now that this notice of defect has been delivered. So the buyer then will send a notice of defects listing only the defects that they and only, well, here, this is where we get gray. So they're listing only the new defects that they have discovered via the inspection, and any defect previously disclosed but found to be of greater nature and extent of the original disclosure. So this is where we get into nature and extent period or portion of that provision. Again, if they're, and I'm gonna let the examples.
Well, the one is in the real estate condition, the seller says there's a trickle of water in the basement. And after the inspection, the inspector notices multiple stainings and things like that to show that there was extensive water in the basement. That's an example of greater nature and extent of which. So that can be used as a defect, even though they were told that there was a trickle of water in the
Yeah.
basement.
And that's where striking those lines just weeds all of that out.
Right.
So, so on that notice of defects, as Joni previously mentioned, this is now, we're past the amendment period. We cannot make a request. Now we're just listing the defects for the seller and whether or not they have right to cure. You're going to list all the defects that the buyer objects to. Again, use the inspection report. And this is where these examples come in. So dampness, a small trickle of water after heavy rains. Yeah. I'm just repeating what we just said. If lines 10 and 11 were struck, then there's no concern about the nature and extent. But point is, we're listing defects now. We're not making requests. We're not over explaining what the defect might be. We're just using the inspection report to list everything that the buyer objects to. And now the seller has their own response to this receipt of the notice of defects. So if the seller has the right to cure, we've received this and this notice of defects, and now we're going to enter into our right to cure period, which is determined by line 218 of the offer to purchase. So it defaults to 10 days. So now we've received this notice of defect, seller has right to cure. Now they have 10 days to respond and say that they are going to cure, they elect to cure, they elect not to cure, or they ignore the notice of defects altogether. If they ignore the notice of defects altogether, once this 10 days is up and there's no response from the seller, then the offer is automatically null and void. So this, well, I'll go to point 2. So if they don't have the right to cure and this buyer delivery of notice of defects happens, then that automatically makes the offer null and void. So you can see how one is more advantageous to a buyer. If the buyer does not give the seller the right to cure, then that deal is automatically null and void. And buyers in their court to kill that deal right away. If the seller has been given the right to cure, now the buyer is put in this waiting game, and the seller now at this point may say, okay, crap, excuse my language. I wasn't willing to fix the foundation and fix the roof and fix these other items that made up for that $5,000 credit. But now the buyer has given a final line in the sand, and now I have to do these things if I want to keep them in this deal, or I'm going to just let them out because I'm still standing my ground. I'm still not going to fix those things. So that's where it's, receiving that notice of defect as a seller, that is where it's not advantageous for them, because they might have been, being headstrong for no reason, and now we get to this point and now they have to do all of these things. So whereas before they might have gotten away with only fixing 2 of the items and buyer was okay with that, now we've been given this full scope of defects that they have to cure if they want to keep the
You have to cure all the defects.
yeah, they have to cure all the defects if they want to keep that buyer in. So yeah, it's depending on how they receive that amendment or receive that notice of defects determines where, or what the seller wants to do with it determines where we go from here. So I'm going to stop share here. So there are many ways to discuss the defects. Trying to get to the gallery view here. You know, a lot of these concepts and the way that we're describing how these things can be handled are repeated in other trainings. You know, focusing just on the inspection contingency. We really wanted
to cure.
Right to cure, the concept of right to cure. It's all intertwined, of course, right? So we just really wanted to focus on seller's obligation as it relates to defects and disclosing, and then how a buyer is receiving this information, and then what they do with the knowledge of these defects when it comes to writing an offer to purchase and where the offer can go. So are there any questions?
Please call Stephanie with any of these too.
I'm going to, before everyone signs off. That's not what I want. Before everybody signs off. Sorry, 1 second still. Here we go. Here's a contract training library. I'm going to put it in the chat section. I'm going to just do one more share here. Bear with us. So this is what I just linked you guys to. So this is our contract training playlist. So these are all of the topics that we have discussed in previous trainings that are all recorded and housed here. So we've got, you know, focusing specifically on what we just discussed, we've got real estate condition report, basic disclosure. This we did back in May. Contract training with a special guest and an inspector, and their process when it comes to conducting an inspection, just the real estate condition report specifically. There is one that I would really love to point out, right to cure. So that concept of who is given the ability to kill the deal, depending on who has right to cure. This is, I think, a really good training. And then also the concept of multiple representation. We're focusing on the 2 hardest concepts when it comes to our the offer to purchase and our contracts. Another home inspection contingency. So again, you guys, just please make sure that you are using these resources and we deep dive into these, okay? And that's what we got.
Good. Great job, Steph.
How are you guys doing?
Good,
Yeah.
thank you.
Okay. We'll see you next week. I think we're talking about the addendum R, the addendum O, the addendum A, those various addendums that could accompany our offers to purchases. So we will see you next week. Thank you.
Sounds good. Have a good day, everyone. Thank you.
Thank you.
Thank you.
Thanks.